Hey, illegal beagles! Today, we have an intriguing legal case that combines scientific experimentation, intellectual property rights, and the interplay between creativity and the law. It's the case of Snoop Dogg versus Drake, and the courtroom is buzzing with anticipation. In this case, Snoop Dogg, the legendary rapper and avid Pokemon enthusiast, is taking legal action against Drake over his creation known as Sparka, a genetically engineered human with a Pikachu head. Snoop Dogg alleges that Drake's experiment infringes upon his intellectual property rights and appropriates his image as a prominent figure in the Pokemon community. To bolster his case, Snoop Dogg may rely on precedents such as Rogers v. Grimaldi, a famous case that explored the intersection of expressive works and trademark rights. This case established that the First Amendment protects creative works that incidentally include trademarks, as long as the use is artistically relevant and not explicitly misleading. Snoop Dogg's legal team could argue that Drake's creation of Sparka infringes upon Snoop Dogg's Pokemon-related persona and misappropriates his image in a manner that could be misleading to the public. On the other side of the courtroom, Drake is defending his experiment as a manifestation of scientific curiosity and artistic expression. He may reference precedents like Campbell v. Acuff Rose Music Inc., a landmark fair use case that set the standards for transformative use of copyrighted material. Drake's legal team could argue that Sparka's creation represents a transformative work that combines elements of human and Pokemon genetics in an innovative and unique way, thereby falling within the boundaries of fair use and artistic expression. In addition to legal precedents, both parties will likely consider relevant statutes. Snoop Dogg's legal team may invoke provisions of the Lanham Act, which protects against trademark infringement and dilution. They may argue that Sparka's appearance, with a Pikachu head resembling Snoop Dogg's association with Pokemon, dilutes his personal brand and confuses consumers. Drake's defense may cite the First Amendment and the freedom of scientific research. They could also reference the fair use provision of the Copyright Act, which allows for the use of copyrighted material in transformative works, as long as it does not infringe upon the original work's market value or purpose. As illegal beagles, we'll be eagerly following this case as it unfolds. The court's analysis of relevant legal precedents and statutes will shape the outcome and potentially influence the boundaries of artistic expression, scientific exploration, and intellectual property law. So stay tuned for updates on this captivating clash between creativity and rights. As always, I'm Illegal Beagle, and I'm going to jail again.